Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about speedy trial rights during COVID-19 pandemic. But before we get to that, don't forget to click like on this video, subscribe with a little bell next to it to be notified of future videos. Let's get to the question. And the question today is, what about speedy trial rights during the COVID-19 pandemic? Which is both a straightforward and a complicated question. I've done other videos, which I'm going to link to here on speedy trial rights in general, just to recap. Speedy trial rights are generally controlled by Rule 48 under the state court system and Rule 248 under the municipal court system, which in the state court system, they have 6 months to give you a trial from the time you plead not guilty or your last waiver of speedy trial. And under the municipal court system, you have 91 days to get your trial from your last waiver of speedy trial or from your entry of a not guilty plea if you have not moved to continue the trial. The complicated part comes about where the global pandemic and the court's desire not to put jurors at risk or the public. We've got orders from the governor. We've got orders from the state court system here. Let's switch over and take a look at that. So this is the main court page from the judicial branch of Colorado. And as you can see, if you click on here, COVID-19, you can see that every jurisdiction has its own basic guidelines based on the number of COVID deaths, infection rate. Obviously, we just started getting the vaccines available this week, so some of this stuff I expect is going to change in the not too distant future. But look, these orders directing state courts started back in March. They went through April. I think the latest one I saw was a week or two ago. If we look at the here we go. This is the Denver, the second judicial district, which is Denver District Courts, which, they have all these administrative orders going up through order number 8, which takes us through, I think, August. There's more that I know I've seen in my listservs and email announcements online that go through October and November, and jury trials have been suspended. Here, hold on. Jury trials have been suspended, but then they were allowed to go forward. And I think one of the first jurisdictions that was doing that, don't quote me on this, was El Paso County, which is Colorado Springs. They started having their jury trials. I know the 18th jurisdiction started to have some trials. Jefferson County, Denver did not, from what I understand, but after that began, the numbers started to rise. Here, let me show you this. So if you look at this, you can see here, thereabouts November. These are just numbers I've been tracking, transposing them from the Colorado Health and Public Environment page. Back in November, our numbers of infection rates started to go way up. The death rate is now starting to go way up. And when you consider that, judges, courts, appellate courts are not going to want to put people's lives at risk. And what they are finding, what you're seeing are mistrials, where they reset speedy trial based on a mistrial, as though you've had a trial and there was a mistrial. Often this happens a week or two before the actual trial date, because the justice order allows no jurors to convene, which means they can't give you a trial, so they give you a mistrial based on that manifest necessity. Sometimes they toll speedy trial. I had a bench trial in a municipal court set in November, and it was continued, but since all bench trials were suspended in that jurisdiction, they simply told speedy trial until mid-January, which clearly goes way past what speedy trial should have been. And all of this is under findings of extraordinary circumstances. So in other words, when looked at it from the point of view of the judges, what they're finding is that they can't have a trial. It's not the fault of the state, and it's not the fault of the prosecution, which is in essence the reason why speedy trial exists, for unnecessary delay. And you can see that. It talks about unnecessary delay. I mean, that's the main reason why the whole rule's in place. That's why you have a statutory speedy trial right, is because of statutory delay, is because of unnecessary delay. And in this sense, because of the pandemic, because it's putting people's lives at risk to have witnesses come in and assemble, to be in an inside room breathing each other's air, when you have jurors that are, again, in close proximity, having to talk for days on end, what the courts are finding is that this is not unnecessary delay. It's a valid reason for manifest necessity to continue the trial and reset speedy. So that's a complicated question. It's a complicated answer. I hope I didn't lose you. If I did, put them in the comments below. We can talk it out there. But that is the question and answer for today. If you would like your own question answered, you can always put them in the comments below, tag me on Twitter, or email them to me. And as always, you have a right to remain silent. If anybody asks you questions about what you have, what you know, where you've been, or anything, you have a right to say, I don't want to talk to you. And if they persist, I want a lawyer.